Yes. Yeah, my lord, please to mention a matter, my lord. To mention a matter, my lord, this appearing in your lordship's list as an application. It's item 302, application 1.
Just wait, because we have been taking last week the applications.
So this week for a different reason, my lord, because the decree holder has made an application in the Shialda court for breaking open the padlock and taking possession. And I told the court that I have preferred an appeal. Court said 17th May is the last day, whatever you want. Otherwise, I'm going to allow the bailiff to break.
That's why I was going to say that from the next week onward, we will be taking up the applications first for the whole of the week. So probably we will be able to dispose of all the applications.
Very well.
So don't worry. From Monday, this week it was a order 41. Next week application.
Matrimonial in order 41. So I expected it to appear application next week.
Don't worry. It will be.
That is the only predicament. Otherwise,
no.
I served the other side.
Yes, just inform him. They will be informed that the application should be taken up.
It's in the list, it's a listed matter.
It will be, yes, that's why the indicator.
I already informed them, it's the list. I have given them notice, everything. Serve them
so from next week, we will be saying that the applications will be given up.
That note in your lordship's list.
Only one indulgence.
Under compelling.
Yes.
Item number 391. Is it 398? It's a
application. Don't worry. As we already said, from next week.
When your lordships are there, no question of.
So we'll taking up the applications next week.
Deeply obliged. Yes. Pardon me for making a tiring reputation.
Thank you. Yes.
Under compelling circumstances.
Yes.
I didn't put it as well as my lord.
Yeah, he's Mr. Kollul Basu.
Everyone has his individuality, my lord.
Yeah, it's true.
I cannot be him, he cannot be me.
Yes.
My lord, may I have your lordship's kind leave, my lord, under compelling circumstances, to mention item number 26. This is appearing under the heading Order 41, Rule 11.
It was called on, sir, last time. Nobody.
No, this was mentioned on Monday. Since then, it's been appearing in the list. 27 onwards is being called on. My lord, the urgency I'll indicate to your lordship. Difficulty, my lord.
Was there.
My lord, it's an appeal against a refusal of an ex parte ad interim order, my lord. They're creating
somebody. This was called on. Otherwise, hey, 26 number ta call kora hoyechilo.
Possibly,
so it was called on.
Would it be your lordship's pleasure to keep it any time?
Nobody appeared. Then what can be done?
Fixes it. I understand. It's fallen from your lordship.
Advocates like you who are just waiting in the queue and.
I'll not take 15
expecting
minutes.
that their
this is a suit for specific performance and permanent injunction.
This was called on. We have taken whole week that up to what matter, then from the next it will be called on. So if it is from 27, then
I understand,
it was called on.
Yesterday, my lord, it was item number 20, 23, 24. Lordship will give me one chance, my lord. They'll create third-party interest. Next week, your lordship has already stated, my lord, is taking up applications.
Because there are
I'll be in immense difficulty. They'll create third-party interest. It's my suit for specific.
It's a list pendants.
My lord, there'll be multiplicity, my lord. There'll be multiplicity.
Don't worry, list pendants will be there.
Lordship, that'll lead to multiplicity. Lordship,
no multiplicity. Who says?
Lordship, I'll have to file another suit against.
No. Who says?
My suit, my lord, was specific performance. They've come up with an advertisement. But they've come up with an advertisement to sale. Lordship, give me 15 minutes.
You are, if you do not understand.
No, I do.
Section 52 of the
Transfer of Property Act. I understand. The difficulties, my lord, it'll prolong.
We'll take up. Don't.
Would it be your lordship's pleasure in that case, my lord? In that
case, because we have been following.
No, I understand. I was there for the mentioning. Yes, I understand.
Whatever. That's there. Yes.
So, indulgence, lordship, item 18 April, your lordship passed the order, lordship. Still now, they didn't upload it, lordship. And on the.
We don't have a control over the uploading of the order, madam.
Lordship.
We appreciate there is a registrar who is overall in charge of this. Go. I think
lordship,
it will be taken.
The difficulty is that they didn't allow me to join. Then I will face the DP disciplinary person, lordship.
You have seen the orders, madam. Everything is there.
The later, lordship, but still now they said that without submitting the High Court order, we did not allow you to join.
I do not know if they give, you just make out an application, we'll see to it if the communication has been made. There is a judgment of our High Court also. That if a lawyers have made a communication communicating the order, that's a sacrosanct.
I have communicated, lordship, before.
So you have to take out saying that this has been done.
My lord, may I be permitted to be mentioned, my lord? My lord, may I be... May I be permitted to be mentioned for upgradation, my lord? It is
Which,
first miscellaneous appeal, my lord.
madam, appeal, just wait for some time. We will be disposing of some matters and then we'll take up. Don't worry.
My lord,
Just give us some time. We'll do it. Yes.
My lord, I'm for the appellant, my lord.
Let पर वही मेमो था
Granted instruction.
You are the advocate and record?
My lord.
Yes. The advocate and record of the appellant submits on instruction received by him in writing from his client that his client does not intend to proceed with the instant matter. Stop. Let the written communication, while today be taken on record. In view of the above, the appeal is dismissed for non-prosecution.
I'm for the appellant, my lord. On interrogation, my lord, the appellant has written a letter before this honorable
Oh,
bench.
this is what? Yes,
Yes,
where
my lord.
is he?
I've not seen him. So on interrogation, he told me one Vishwajit Day
Where is he?
drafted.
He was supposed to come.
Yes, my lord, told him repeatedly to come before this honorable court because he can identify the learned advocate. But and so far track report concerned, my lord, it says that
Have you caused a notice on him?
my lord, Vishwajit Day, as he told me.
Have you caused a notice on him?
Yes, yes,
Sujit Dey?
Yes,
Has
but
he received?
no, my lord. The postal endorsement is that on hold address cannot be located. It is the address of the civil court, as he told me. I do not know the personal address of this learned advocate.
Court?
Asansol Civil Court. And there are two advocates in the same name, Vishwajit Dey. One practicing in criminal side and another civil side.
Where is your client?
Yes. Yes, he is coming, my lord. And
Yes.
one more request, my lord.
So,
He's told me that I am not defending him in this matter so far as the later APC is concerned. Therefore, he want to engage someone else. And personally, I'm not. I want to get a release from this matter. So, my lord, kindly allow me to.
whom he want to engage?
Does not tell me now.
Ask him.
কাকে এনগেজ করতে চান আপনি? আপনি ম্যাটারে কাকে এনগেজ করতে চান? আপনি ডিফেন্ড করার জন্য এই লেটার ব্যাপারটাতে কাকে এনগেজ করতে চান?
আমরা এখন ঠিক করে লিগ্যালিটি যেটা
He said he wants to go legal aid. He said, yet not he decided yet, he wants to go legal aid.
You are not appointed from the legal aid.
No, my lord.
So he want to go through a litigation. Has he communicated to this lawyer, Biswajit Dey?
আপনি কি বিষয়টা কি জানিয়েছিলেন? বলেন যে লেটার দিতে
লেটার দিনই আমি ওই নেটে পাঠিয়েছিলাম ওই
WhatsApp.
ইমেল করে দিচ্ছি
He sent it to WhatsApp.
He knows that person.
My lord.
He knows the person.
Yes.
Knows the person.
Yes.
So we are permitting you, don't worry. But we do not want to release you right now. For one reason, because we don't know on the next day when the matter is there, he will not be able to engage another lawyer. We just wanted you to just facilitate the entire thing that is there. So ask him to immediately go and communicate the order to him that he is required to remain present in the court.
Okay.
If he does not, then please collect that address. We know how to secure his presence. That we know. Yes. communicate to him what we wanted to say.
Well, he's saying he do not know the address of the learned advocate. Then না না এখানে না আসানসোল কোর্টে অ্যাডভোকেট এখানকার নয় না 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 না
Where you live?
why not
Where you live? Where is your native place?
my নাকতলা টালিগঞ্জ নাকতলা Calcutta.
Native place.
Yes,
Don't have any Asansol connection.
the clients have come from Asansol, no connection, no direct connection.
Send it. On hold, addressee could not be located, whatever is there.
That's-
So we do not want to go much deep into this.
that's-
What we are thinking that how to ensure his presence. What is your suggestion? Because I over here, he was saying that we contacted him and he says, I am too busy, I can't go.
that's it.
If I correctly overhear him,
All way, my lord, kindly inform the local police station.
it's a big, can we permit the police to enter into a bar association and then
Otherwise, my lord,
you realize that particular ramification?
because his personal address is not known to us, only the court address. So
We certainly want him to be here. Anybody has a route at Asansol or connection with the Asansol bar?
Sharanya Chatterjee is residing in the Asansol. Sharanya Chatterjee.
Who is he?
Just now I
Competent persons to shop with the shop of management. He has the connection with the bar association of the Asansol. The shop of management bar.
Can you call him? Call Mr. Sapul Manager.
countries.
Asansol or
Asansol.
what?
No, Asansol. His father, Mohit Mukherjee is criminal lawyer.
Criminal?
Criminal lawyer, eminent criminal.
Where is a criminal?
Criminal side practicing.
Hey, that
Criminal
they are
side.
practicing in the criminal side. That is why I understand.
Sharanya Chatterjee, Asansol.
You have a connection with the bar, Asansol Bar Association.
My lord,
You live there.
my aunt is a practitioner there.
What position she holds in any bar association?
She's a senior advocate there. No, not a position there.
Thing is, there is one advocate who is there. He has facilitated the appellate hearing to do certain things, which is beyond the ethic of an advocacy. So we wanted his presence to be here. We directed the service of notice. It was sent by him. Postal department indicate the endorsement is that the item is put on hold, addressee cannot be located. And it is a bar association where it is sent. Maybe at the time he is there in another whatever. That may be a reason. We are not really taking so serious, consideration. So we wanted his presence. The litigant who is before us communicated to him that he also contacted him. I think that what I could wants your presence. He says, I'm too busy, I can't go.
But I can communicate, my lord, with the concerned person of the bar because I have some acquaintance.
With the president or the secretary.
My lord, I can get hold of the number of the person.
Yeah, phone.
his phone number is there. His phone number is there, my lord.
His phone number is
Yes, he has already WhatsApp the message, so I can collect the phone number.
But communicating him will not do because we wanted to ensure and we do not want to take that recourse which you are suggesting.
Otherwise, may I send a message in my WhatsApp?
You can send, but we want to ensure his presence.
Will the secretary be communicated, my lord?
Then my lord kindly directed the secretary of the Asansol Bar Association to ensure the presence of current advocate before this honorable court.
Sure, if he says I will not go, can you impress upon him?
That is the critical thing. Let's put the point.
For the appellant led by Mr. Hon'ble Krishna. The Lordship, my lord, one stamp vendor report is there, my lord. To put the notice, I have submitted the Talovana and the notice and the deficit fees.
Have you put in the requisites?
Yes, on 24th April 2024 and 25th April.
Within a week.
Yes.
So why lodging not?
My lord, it was your lordship direct the matter will appear under the heading lodge. Last official.
After a week, just to ensure that you have deposited.
Yes.
Give us the
My lord, it is showing in status of the, my lord, I have, like, because no documents has been given. Now the department is, my lord, this is the status.
by an order dated
Five, I am for the appeal. My lord, there was direction by the learned Lojima court to file requisite for the notice, service of notice that has been completed.
but should come before us. No, Mr. Indra, you are, what is your good name?
Bikramjit Mondal. Bikramjit Mondal.
Where
My
is
name.
Mr. Indrajit?
My lord, his younger brother has expired.
Who?
My lord, is Sujit Mondal, his younger brother has expired.
No, the difficulty is there are two things. The application for substitution is taken out beyond the statutory period, and there was a direction to file supplementary affidavit.
So, my lord, we will file within 2
Within
weeks.
5 means. Certain applications for it was after that. So supplementary set aside the 3 minutes. Where is Mr. Omid? I understand Dr. Mondal.
My lord, he is advocate on record of the case. He was junior to Miss Dr. Mondal, but he is not associated anymore with Dr. Mondal.
But whatever the
And I telephoned him yesterday, but he says that he met with an accident 3 weeks ago, so he is not coming to court.
What is your good name?
Bikramjit Mondal.
Mr. Bikramjit Mondal appear Yes. Next. Especially this matter. Next week we'll take up all these 4 orders because today is only 1/2 day. So unnecessarily the entire 4 orders will consume. Better continue. Better next week. Yes, sir. Why primary school has done?
School is the apple and before lords. School is the apple. I have submitted, my lord, translated copy of the.
First tell me who are the trial court.
I am for the defendant.
You are a defendant. Suit for
Suit for declaration of title and permanent injunction. Permanent injunction
you
from interfering the peaceful possession of the plot.
and both the courts have gone against you.
No,
Judgment of reversal.
my lord.
Trial court declared the suit. Dismissed the suit. The appellate court has reversed. Why the appellate court reversed it?
At the time of hearing of the appeal, the appellant formulated 4 questions of law. Thereafter, appellate court passed the judgment on the ground that defendant has no right, title, interest over the property in questions on the basis of the RSROR, which is wrong.
Finally published.
Finally published. Finally published record of rights.
You have no right of audience unless the ambition.
My lord, and also directed the defendant to remove the construction wall.
That we have seen.
Right.
On the basis of a RSROR.
RSROR.
Was there any deed produced by him?
Deed, my lord, in the year executed in the year 1915. 15, but it was not registered because of the fact the consideration value was
100 below 100.
But thereafter, my lord, thereafter we could not produce the deed before the trial court. There was a devastating flood in the year 1978, and all the documents has damaged.
What deed?
Deed, my lord, deed transferred in favor of the schools.
By registered document?
By not registered, but executed.
Of the year?
Year 1915.
That was their deed.
Deed.
That was their deed.
Deed in favor of the school. Transfer in favor of the school.
1915 deed is only, that was in your favor.
Your favor, my favor.
And what is their deed?
Their deed, what happened, my lord? Placing the facts, my lord. Originally, land belongs to Jhoru Manna and Indru Manna. Jhoru Manna inherited the property 50% entire share of Jagannath.
Yes.
And Indru Manna died bachelor and his property devolved upon Jhoru Manna.
Originally belonged to whom?
Originally belonged to Indra Manna and Jagannath Manna.
Indra Manna
Manna.
and
Jagannath Manna.
Jagannath.
Jagannath.
Yes. Then
And Jagannath Manna, Jhoru Manna was the son of Jagannath Manna, Jhoru Manna.
Guru Manna.
Huh.
Guru Manna is a
It-
son.
He inherited the entire property of Jagannath Manna.
Jagannath.
Jagannath.
Then
And Indra Manna died as a bachelor.
died bachelor. Then
Bachelor. His property devolved upon
the relation between Indra and Jagannath,
two brothers.
two brothers. Full blood brothers.
Full blood brothers. Thereafter, my lord, Indra Manna's property devolved upon Jhoru Manna.
Then
Thereafter, school made a request to Jhoru Manna and Indra Manna to
Guru Manna was alive at that point of time. Oh, yes,
to transfer some portion of land
some portion.
for construction of school building.
School requested to transfer some portion
Some portion of land in three plot, in respect of three plot.
of land. 3 plots. Then
In respect of three plots, my lord,
when
when 1915
1950. Yes. Then
and deed was executed in favor of the school.
deed
Was executed, sale deed was executed in favor of the school,
not part of the record.
not part of the record.
Not part of record. Then
Thereafter, my lord,
unregistered.
unregistered,
Yes.
below 100 rupees. Unregistered, my lord. 100. Thereafter, my lord, in the district settlement record of rights,
Yes.
district settlement record of rights, the land was recorded, original land was recorded in the name of Jhoru Manna and Indra Manna.
The name. Which record of right?
District settlement record of rights under the Bengal Tenancy Act.
District settlement.
Before sale,
Yes, it's district settlement.
record of rights.
ROR.
ROR. DSROR
Yes, in the name of Indra
and
and Jhoru.
Jhoru.
Then
Thereafter, my lord, Estate Acquisition Act came into force.
Right.
In the year 1956,
yes,
in the year 1956, the record of rights, draft publications and finally published record of rights was recorded in the name of the schools.
it was after district settlement. What about the CS?
DS,
CS is there. What about CS?
CS has not been
Not very.
a
After estate acquisition, the RS operation came. Then RS record of right stands in whose name?
name of the original plot in favor of the school.
What?
The plot was segregated, Bata plot.
Bata plot.
Bata plot in favor of the respondent,
Bata plot. School.
in favor of the schools,
Correct.
not in favor of the school, in favor of the respondents.
Bata plot in favor of respondent.
Respondents.
See that?
And origin
Means
and
Indra and Jhoru. They are claiming through Indra and Jhoru.
at that time Indra was died, only Jhoru Manna.
Jhoru. So it was in the name of Jhoru.
Jhoru.
Then
Thereafter, my lord, original plot recorded in the name of the school. Original plot recorded in the name of the schools.
this was Bata and the
Ah.
original
Bata.
plot, the name of school. And then
My lord, three plots. One is DAG number 1349,
1349,
5 decimals,
whatever, 5 decimal.
1 decimals of 1350
1350,
and 5
1 decimal, then
and 5 decimals of 1352.
1352, 5 decimal.
5 decimals. Name of the
Total 11 decimal.
11 decimals.
Then school. And
There
what
are
is the composition of bata? Bata of what?
Bata, my lord,
The plot number
1349 by,
5.
my lord, I am coming. Bata plot 1349 by 2960,
960,
1350 by 2961,
961.
and 1351 by 2962.
So all these plots and these are all this bata plots comprised of
Comprising of 7 decimals and 2 decimals. 7 decimals of land total
in total all of out of 3
out of
composite 7 decimal.
7 decimals.
So you got 11, they got 7.
7. Thereafter, my lord, in the year 1964 onwards,
Yes.
till 1979,
Yes.
the sons of Jhoru Manna had 3 sons, my lord.
Sons of
Satish and Sipoti transferred their 2/3 share in favor of Rotikanta.
That share has been transferred to whom? By the sons
Not
of Joru.
entire share, 2/3 share.
Sons of Joru. In 2 sons of Joru.
Jhoru transferred to another son Rotikanto. Another son Rotikanto. Roti.
Rotikanto. So Rotikanto become absolute owner. Then Rotikanto.
Rotikanto was the predecessor in interest of the plaintiffs.
So the plaintiffs are the sons and daughters or grandsons, whatever.
Sons and daughter. One daughter and one son. In the
So Rotikanto claimed the absolute right in respect of the entire 18 decimal of land.
original plot
18 decimal of land.
land.
Because they acquired
My lord.
decimal and then 11 decimal.
My lord.
So 18 decimal, they
18.
noted that they are the owner.
No, the deed was executed in favor of Rotikanto since 1964 to 1979.
By
By-
other two sons or their successors.
Successor. And in the sale deed, specifically stated the Bata plots. They transferred the Bata plots.
They transferred,
The Bata plots.
which is in your favor.
No. Bata plot in favor of the
Oh, there. Okay, okay. Mentioning the Bata plots.
Bata plots.
Then?
Then, my lord, in the year 1986, the Rotikanto, the predecessor interest of the
He died.
he filed a suit
Okay.
for a declaration of title and permanent injunction.
What is that suit? School. White suit.
Declaration of title and permanent.
Title suit.
Title suit relating to that property.
Number.
Title suit numbers, my lord.
This has not been
It
document is produced.
it was summons was served, but it was dismissed for non-prosecution on 26 June 1986.
Dismissed for non-prosecution.
Non-prosecutions. And they have not made any averment in the plaintiff relating to that suit.
They may not be aware of it because it goes against you. If your suit is dismissed.
No, not my suit. Rotikanto filed a suit.
You said school filed a suit. So I recorded that.
Rotikanto filed a suit. Well, I am placing predecessor of interest of the plaintiffs.
He says school filed a title suit for declaration. This was the Rathikant who filed a
Plaintiff's father,
whatever. So it was dismissed for non-prosecution.
non-prosecution.
Whether you were present,
No.
No.
I am not present,
so it is a dismissal under order 9 rule 4.
my lord. Not,
How it is material?
it is not material, but it has the facts, my lord. Thereafter, my lord, in the year 2001, the heirs of in the year 2001,
Yes.
the heirs of Ratikanto filed a suit,
This present suit.
present suit,
Yes.
present suit.
Then?
In the said suit, they have
Don't mention about the non-prosecution.
non-prosecution,
No, immaterial. Right?
immaterial,
Then
my lord. In the subsequent suit filed by the plaintiffs, they have paid a degree for declaration of title
got it.
and also, my lord, also,
For removal of custody.
and also declaration the record of rights is erroneous and without jurisdiction,
Section 54B.
but without imprinting the state respondent as a party in the suit,
Let us see. See, there are 5 prayers.
my lord.
One of the prayer cannot be granted in absence of some of the parties. How difficult? The court cannot dismiss the suit as a whole if the other prayers can be granted in presence of the
My lord, I am not that. I am that the non-joinder of necessary party,
This is what I am all talking about, or what I talk about.
my lord. Thereafter,
If they wanted a correction of the record of right, then the state is a necessary party. But suppose if the court says I am not going to pass a decree for correction of the record,
my lord,
then also the state has to be made a party. No.
No.
Then he can proceed to decide the
Title.
title of the parties.
Title.
vis-a-vis
but here appellate court
themselves.
decreed the suit on the ground the defendant has no right, title, interest on the basis of RSOR, which is wrong. Which is wrong.
That declaration can be done. What 54B says, bar, correction of the record of right is within the domain of an authority.
My lord,
And therefore, no civil court will entertain that.
my lord,
But whether the civil court is denuded of making a declaration that this is erroneous, there is no difficulty. It is only the court who can pass an order, but cannot direct for record rectification or
of record of rights.
the record of
My lord, what happened in the year 1956, when the final publication record of rights, Satish and Sipoti was present, and Bata plot was recorded in favor of 3 sons of Jhodumanna.
use all those documents that there was a proceeding initiated there, and this culminated into an order. Revenue officer or the competent authority initiated a proceeding under the West Bengal Land Reforms Act
Estate Acquisition Act.
or under the State Acquisition Act, and then recorded it. Have you produced those orders?
My lord, it has been exhibited.
Asking, have you produced those orders?
My lord,
Has been exhibited.
exhibited. Thereafter, in the suit, what happened? They pray for advocates commissioners. For the construction was going on in the suit plot. A report submitted, the construction was going on. Thereafter, my lord, plaintiff filed an application under Order 39, Rule 1 and 2 of the Code of Civil Procedure for temporary injunction. It was contested, and trial court passed an order in the form of status quo. Thereafter, my lord, against that order, we preferred an appeal under Order 43, Rule 1, small r. During the pendency of the appeal, misappeal, we had given an undertaking. If the suit is decreed, we will demolish the building. We were constrained to give undertaking because of the fact the government granted a grant in favor of the school. The school was initially absolutely a mud house. And in the East Midnapur, school was submerged in every year during the inundated of water. That is why brick built building is required for the students' education. Thereafter, my lord, after hearing both parties, the learned additional district judge allowed the misappeal by setting aside order of the trial judge under order 39, rule 1 and 2.
The basis of that undertaking,
Undertaking, we are constrained.
disposed of the appeal, setting aside the order of the trial court in view of that undertaking have been given.
No,
No.
no, Lordship,
On merit,
on merit, Lordship kindly,
irrespective of undertaking,
Lordship kindly come to the order.
then we are not concerned.
Thereafter,
These are all
my-
interlocutory one.
Thereafter, my lord, we have filed a written statement. In the written statement, we have given the details for acquisition of title by way of record of rights, finally published of record of rights, and we are all along in possession and also uninterruptedly and peacefully enjoying the property. And also thereafter, LR record is there in our name has been recorded. And we also paying rent in favor of the government. After considering the evidence and materials produced before the court, the trial court dismissed the suit on the twofold ground. One, my lord, section 34 is a bar. Section 34 of the Pacific Relief Act.
Oh.
On the
Not wait for any further release.
my lord, one ground, and other ground, my lord, when the land was recorded in the finally published record of rights, it was within their knowledge, but they did not raise any objection to that effect. Thereafter, deed was executed in respect of water plots. They were aware of that. They did not take any steps. In the year 2001, they had filed a suit. After more than 50 years, 42 years, it is also hopelessly barred by limitation. And 12-year limitations already over. That is why, my lord, suit dismissed. Against that, appeal was prepared. Appeal court held mainly bank upon the evidence of headmasters of the schools. A headmaster could not produce the deed in the year 1915. Headmaster could not produce the resolution which was taken earlier managing committee. At present, there is no managing committee, it is monitoring committee. That is why appeal court heavily relied upon the evidence and also hold that plaintiff had title. Record of rights does not get any title. Therefore, plaintiff proved their title and decreed the suit, and also directing you have given an undertaking. On the basis of such undertaking, building should be demolished. Against that appellate court order, we have come before your lordship. My first question before your lordship, the appellate court did not, without touching the judgment of trial court, without touching the findings of the trial court, without considering the exhibit, appeal court passed the judgment of his own volition. And section 96 and order 4131, my lord, principle, order 41, rule 31, CPC, the appellate court should have disposed the appeal with a provision of civil procedure code. The first appellate court is the last court of facts and
law.
And or
Both.
My lord.
First appellate court is the last court of fact and law.
Law. My lord, here, my lord, first appellate court deviated from that.
The substantial question of law, not every question of law.
My lord. She did not touch any point of the trial court. And there is no whisper in the judgment of the appellate court. While the reverting of judgment, Order 31, Rule 31, my lord.
Yes, I
My lord, Order 31, Rule 31. I am reading, my lord.
have already read.
My lord, your lordship,
I have already read.
your lordship knows better than me, my lord. My lord,
My brother is more.
my lord, there is a specific commission regarding reason must be given. My lord,
Running in several pages according to you.
no,
What
not at all.
talks about that the entry in the record of right is not the document of title. It's not a recording of reason.
My lord, record of rights has a presumptive value regarding possession. But that presumption must be rebuttable. Plenty measure.
Whether the possession automatically creates a title.
Sometimes, my lord, possession follows title. Title follows possession. At the same time, possession follows title.
No, title follows possession.
Possession. But he must have to prove that the recording
Possession follows the title.
possession follows the title sometimes.
Why am I aware that the possession is one of that is a 9H principle of title.
My lord, I am giving an inference, my lord. Record of rights. Finally published. Thereafter, LR. At the time of final publication of right, no objection was given. And possession was,
How it was done?
my lord,
By virtue of Bujara, by virtue of Khanapurti,
thereafter attestation,
how it was Bujara was done.
my lord, it was as a,
Taint on the open.
my lord, bid by way of, my lord,
Taint in the open mart, invite
my lord,
everybody comes, I am there, and then recording the name.
no, my lord. It was by way of bid of,
The Bujara.
my lord, Sotish and Sipoti, son of Rovikanta, was present at the time of,
Get the documents, sir.
My lord.
The first question is again, whether the entry in the record of rights creates any title into a person. A person may be found in presumptive value of possession, he must be found in possession. But it does not mean that this possession backed with the title. If the person's possession is ultimately interfered with, then in the agreement what? Where non-possession that amounts to a conferment of title.
no, not at all.
You know,
My lord, I am,
so this is what I am just thinking about. That what are the effect of this? You claimed the title since 1915 on the strength of a sale deal having a consideration below ₹100. So in view of the provisions contained in the Transfer of Property Act and the registration, it is not required to be done by a registered document. It is not compulsorily registrable in nature. But you could not produce that deed. Whether it has been destroyed in fire, tempest, flood, cyclone, storm is a different aspect. You are claiming title, you have to produce it. You could not produce even a scrap of paper. But
my lord, I beg to submission, lordship. We have exhibited 5 documents. Lordship, kindly come to the trial.
record of rights.
Then we see record of rights.
Suppose a government accepts a rent, it is not supposed to accept. Does it confer a right or extinguish a right of a rightful owner?
My lord, I am submitting when the record of rights was prepared on the basis of the deed. Subsequently, it was lost. How the record of rights?
That's why I just pointed it of a Khanapuri and a Bojara. How those record of rights were maintained. Was it a soap-proof, foolproof?
My lord, lordship, kindly come to the findings of the trial court. specifically praised for adverse position. Plaintiff made a statement for adverse position.
Why they will claim adverse position?
That I don't know, my lord. They are claiming that they are 80 years, they are in position, that is acquired by adverse position. And our client also,
But their paramount claim is that on the strength of those deeds, they have acquired the title.
but a plot, not ordinal plot. Deed specifically stated in the recital that Bata plot.
Bata plot or no Bata. If you go by it, there is no distinction. There is no dispute to the admitted fact that the original property belonged to Indro and Jagannath. Now, Indro died bachelor, there is no dispute to that. Jagannath died leaving a Jhoru, Parna as an owner, as the only successor. Your claim is that the Indro was alive and the Jhoru was alive. They executed a deed of sale in your favor. You have not been able to prove that the deed, that how you got it. Whether the son of Jhoru, two sons of Jhoru has transferred their share in favor of Rotikanto is a internal matter between them. Suppose if it is not, suppose no deeds are there, then at least this property of the Jhoru would devolve upon his three sons in absence of any Bata plot. If the three sons are there, then so far as the Bata plots are concerned, that would be treated as the exclusive property of Rotikanto. So far as the non-Bata plots are concerned, it will be a property of all three sons.
No.
Why not?
Because it was transferred by way of deed.
Where is the deed?
That is,
Where is the deed?
that
Deed
is,
is non-existent.
that is my,
115 deed is not there.
that is my,
Neither here nor there.
my lord,
How?
it is our specific plea that deed was lost.
Sir, but something has to be proved. Somebody who has seen executing the deed, something has to be done. In 1915 deed, how you will get a witness?
And it cannot be placed 100 years old document.
What I'm saying, there is no document, sir. You say there was a document lost. Where is the document?
We get
Any copy of the document, anything of that kind.
only, my lord, record of rights. How it can be recorded? Unless the deed was presented, how it has been recorded, my lord. Not only that, my lord, they did not challenge that. And in, my lord, I am citing two decisions of the Honorable.
And also cite 1993 volume 3 SCC, 1994 volume 4 SCC. Simultaneously, sir.
I am citing, my lord, current decision of the Honorable Supreme Court. Here, my lord, section 27 of the Limitation Act also considered. 27, Article 58 and Article 65.
Sir, please.
Paragraph 11 onwards, man. Paragraph 11 onwards, my lord. Various contention have been canvassed by other party to a dispute. However, if this court to decide those issues, two questions must be considered at the threshold. They are
Just 1 minute. Paragraph 10. I'm getting it. Oh, yes.
uh, 2024 INSC page 109.
Yes. Yes, sir.
The High Court degree observed that because of 34 of the Pacific Relief Act 1963, the plaintiff not being in possession. Here, my lord, plaintiff are not in possession. And claiming only declaratory relief ought to have claimed the relief for recovery of possession.
He has prayed for another relief as well. He has prayed for permanent injunction. He has prayed for permanent injunction.
Here also prayed for permanent injunction. Suit for,
You say, here also prayed for permanent injunction.
my lord,
In this case also.
my lord,
So is it part of the section 34?
34.
Is it?
My lord, it was held that the trial court rightly dismissed the suit on the basis the plaintiff has filed this.
Sir, you have seen that.
My lord,
Your undertaking is on record.
undertaking, lordship kindly come.
That undertaking is already on record.
My lord,
To vacate the moment.
undertaking is not the part of the degree. Because of the fact undertaking was given in the miss appeal before the degree was passed.
Sufficient. So what is there? There was a suit for declaration of title. On declaration of title. Suit for declaration of title. He has claimed title in respect of the property. Decree for declaration. They have not claimed. What? What's relief?
My lord, নিম্ন তফসিলি বর্ণিত ভূমি বাদীগণের ওয়ারেন্ট সূত্রে প্রাপ্ত সত্ত্ব দখলি
What is the sotto? What does it mean? Declaration of title?
ভূমি থাকা ও ওই ভূমিতে বিবাদীগণের আদৌ কোনো সত্ত্ব বা অধিকার না
That is
থাকা।
not a negative declaration against you that you do not have any right. So this is the declaration of title. And then a nishat, permanent nisatagga. That is where also there.
There is also another prayer, Lordship. That is core one. He's perhaps not reading that. Subsequently, it was amended. Nalishi RS.
That amendment was rejected by the Honorable High Court. And Honorable High Court deprecates the appellate court.
We are concerned with.
My learned friend is not correct, my lord.
We are not hearing her.
Right.
First prayer which you have just read relates to a declaration of title.
And also correction of record of rights.
Permanent injunction.
Is a consequential relief.
Or
Consequential relief.
correct. Suppose you are saying that he has not prayed for recovery of possession. Section 34 bar. Tell me it is bar.
But as per judgment of the Supreme Court, I am citing another Supreme Court judgment. Clearly said, section 34, declaration of title.
Akamma, which is reiterated in this judgment. Have you seen just Akamma's judgment?
I am coming, my lord.
2021. SSC online. You have the Akamma judgment. By Justice Aniruddha Bose. Have you got that judgment?
No, I am citing 2017 volume 3 SSA.
See that Akamma is a very important judgment which is relied upon. Come to just above paragraph 31 on the line of this judgment which you have cited.
Relied upon. By relying upon that judgment, Supreme Court held which judgment I have cited that.
Read Akamma, what it says.
But that has been considered by the subsequent judgment.
This is what I'm saying. You are citing this judgment. I am inviting your attention to this judgment which you are citing.
My lord, that has been considered.
Please just go below paragraph 31, last sentence.
Well, by considering that judgment, Supreme Court delivered same judgment. My lord.
Have you read that judgment of Akamma? That is what I am driving at. Have you read the judgment of Akamma? Have you seen the fact involved in Akamma?
He is relying on citing a judgment.
And this judgment solely relies upon Akamma.
Only 1 minute, my lord.
Just
Akamma. Akamma, two judgment.
This is also two judgment.
Two judgment.
Are you aware of the fact of Akamma?
Akamma, here my lord relied upon
It has not been said anywhere.
the purpose behind section
No,
34.
No, nothing has been said. Now, I am giving you a fact.
But my
I
lord,
am giving you a fact of Akamma. Kindly,
subject to your lordship feeling, which is lordship mind, it is a divergent view.
No, it is not. No, that is why one has to understand this. The Akamma was that the plaintiff there filed a suit simpliciter for permanent injunction. That suit continued and ultimately dismissed by the trial court, holding that the plaintiff has miserably failed to prove his position in respect of the property, and therefore no permanent injunction can be passed against the defendant. Appeal, dismiss, thereafter they did not pursue. Subsequently, another suit is filed by the plaintiff for declaration of his title and permanent injunction, restraining the defendant from interfering with his possession without any relief or recovery of possession, which was the possession was held with the defendant in an earlier suit. Then the question arose before the Supreme Court in Akkam that once the court has declared that the plaintiff is not in possession, then in a subsequent suit filed by the plaintiff, must pray for recovery of possession. Having not prayed, then section 34 bar, which you are also claiming.
I am claiming, my lord.
That is not. Then the question arose that is it because the provisos of section 34 does not talk about that the relief, what relief should be claimed. It simply talks about a further relief than a mere declaration. So the court has made a distinction between an appropriate relief and a further relief, and says that it is immaterial that he has not asked for a recovery of. If he has prayed for permanent injunction, that is a further relief sufficient enough because he claimed possession in his claim. We are not concerned what has been held in the earlier proceeding. But the suit cannot be said to be not maintained. Suit may ultimately fail on a score of evidence, but not on the score of section 30. If that means the fact and the judgment, and this is relied upon by a subsequent.
Relied upon, my lord.
Yeah.
Paragraph 30.
Yeah, you are saying that
the purpose behind.
He knew it that those record of rights have been prepared, which has a presumptive value of possession. He knew the right to sue arises when this finally published record of rights. This is what I could gather.
Not only that, when the deed was registered.
Do you think that emanates them? First thing is, when you take advantage of Article 58, you say that within 3 years he has to come. This is the judgment that seeks. And when a right to claim a declaration that arose when the finally published record of right is there, then in that event the suit is barred under Article 58. Secondly, you say that so far as the limitation period for recovery of possession is concerned, it also provides 12 years. Having not prayed for recovery of possession within 12 years, then also the suit for declaration would fail. This is what I learned. But one has to understand the judgment in the perspective of the facts involved there.
My lord, lordship kindly paragraph 30, which
the fight amongst the siblings.
My lord.
When the mother executed the deed in favor of 2 sons and then 1 daughter, and there was a settlement deed and all, everything was there. And then in that perspective, it was where the rival taxes were paid by the party.
My lord, lordship kindly page paragraph 30, the judgment which your lordship said that has been relied upon.
Only one line without indicating what the fact was there in the account. That is what I am very inviting. Only the last line above paragraph 31.
that the opposite proposition has been reiterated in Akamba. That's the only thing about Akamba. But one has to understand what was the fact involved in Akamba.
Well, now Supreme Court says if the suit for permanent injunction simpliciter, title must be there.
No, no.
I have seen one
no,
judgment, my
there-
lord.
There is no dispute as to the title. Section 34.
If
says
there is
that
a cloud-
somebody attempted to invade your status or a right, or have invaded your status or the right, then the person can approach the civil court for this.
Not simpliciter injunction,
Again, I am saying.
but you have to prove your title in the property. Then you will get the injunction.
I don't think so, sir.
Well,
It has been come across
well,
in the several.
I could not bring the judgment. Supreme Court says recently.
The suit simpliciter for permanent injunction.
Title must be there.
What I'm saying, if there is no dispute on the title, then why I have to seek a title, declaration on title?
But earlier conception was different, my lord. In the
Earlier conception
Sure.
was always uniform. If there is no dispute as to the title, then in that event, there is no necessity of seeking a declaration of title.
if there is no cloud in title,
That's true, what I'm saying.
but here there is a cloud in title.
Then that's why he asks for a declaration. That's why that is even with section 34.
But that declaration not as per section 34. But there is a bar.
34 says, read.
They are not in possession.
Sorry. I do not think so. Where is the specific relief act?
Section 34 of the Pacific Relief Act. Well, I am reading, my lord. I have hand over the book, my lord.
No, I have. Don't worry. Yes, I got it. Please read. Section 34.
Any person entitled to any legal character
Correct.
or to any right as to any property
Correct.
may institute a suit against any person denying or interested to deny his title to such character or right,
Correct.
and the court may
Denying. If I say that nobody is denying, the defendant is not denying my title to the property, but he is trying to invade on my property.
no, it is the plain case. We have denied their title. That is their case.
Mindset has to be processed. I am not talking about this judgment or
My
this
lord.
case.
My lord.
Sir, it is in a broader perspective to understand
I am sorry, my lord.
the intention of the legislatures under section 30. What they wanted to say. Forget about this. Let us talk law.
My lord. My lord, I am deeply obliged.
This is what I am saying.
My lord, my
They
lord.
say this. Don't.
It is a legal deliberation.
Be impartial.
My lord.
Load this partition mind.
My lord.
Come.
No, my lord. I should not be.
Yes. What it says is when somebody
My
is
lord.
denying your right,
Interested to deny.
deny or interested to deny your right. That means somebody says, no, I am not. You're not. Then this section,
Then, my lord,
declaration has to be sought for.
his title to such character or right, and the court may, in its discretion, makes therein a declaration that he is so entitled.
So that is what it says, that when somebody denies my title or anybody's title, then it is obligatory to claim a declaration as to the title, and the court can grant a declaration. Then proviso is,
And discretion should be
then
used,
the
my lord,
proviso-
judicially.
Then the proviso is inside.
Proviso, my lord. Provided that no court shall make any such declaration where the plaintiff being able to seek.
Declaration referable to the earlier enabling provision.
My lord.
Bear in mind that denial of title.
My lord.
So,
Provided that court shall make any such declaration where the plaintiff being able to seek further relief.
it does not say appropriate relief.
My lord. And deeply obliged, my lord.
It all says, it does not say, that is what the Akamba says. Or the relief, not an appropriate relief. There is a distinction.
Distinct. My lord, and deeply obliged.
Everybody is arguing an appropriate relief.
appropriate,
which is not synonym of further review.
my lord.
I have claimed that I am in possession. Though in an earlier proceeding, the court has held that I am not in possession, but I asserted. The court will not believe me at the time of deciding the issue. That's look, there is already a declaration against you. You are not entitled to degree of possession relating to protection of possession.
My lord.
Say declaration as to confirmation of possession, we are also claiming. So the court will deny. But not 34 cannot be above. It will be a decision on the issue, saying that sorry, we are not going to hold that you are in possession. So you are not entitled to a decree for confirmation of possession. I may refuse to pass a decree for it, for the permanent injunction, protecting your position.
Apart from that, declaration may be granted.
It is what happened. It says there is no bar that if a further relief cannot be granted, that does not mean that the court cannot grant a mere declaration.
Declaration.
The court can grant a declaration. This is what I'm saying. Here they have claimed. They claim possession in the claim. Because they claim adverse possession. I do not know from where they got
My client is also praised for adverse position.
the rival. So position is claimed by them. And it appears in course of the proceeding that certain constructions have been done. Status quo was granted. Then status quo was vacated on the strength of your undertaking, which you say under the portion, constraint, compelled, whatever those adjectives are. The bottom line of the story is that you were permitted to construct. Now,
So dismissed.
suit is decreed.
Agreed.
The construction
Thereafter, my lord, appeal is pending before your lordship.
undertaking has to be reverted.
My lord, appeal is pending before law. It's the continuation of suit.
Ultimately, the appellate court held that you have no time. This construction has to be removed.
But appeal court judgment is absolutely vice of perversity and patent illegality.
That's what
I am coming, my lord, your lordship, coming back.
I think so.
Appeal court did not, appeal court my satisfaction, Lordship, kindly have a look to the order of the Miss Appeal. In the stay petition, my lord.
Yes.
In the application for stay, page 22, my lord. My lord. I am kind, my lord, decision with reasons. Peruse the entire material on record vis-a-vis the order of the learned court below. Suit property originally belonged to Indra Manna and Jagannath Manna. On demise of Jagannath Manna, his only son. Page 23, my lord. Decision with reasons.
I have already read, very
My lord.
small one. Very small one. Which portion you want to highlight?
My lord, the appellant had a school building on the adjacent non-suit dock number 1348. Suit property are as here under. Plenty possession and school possessions. Schedule was given, my lord.
Very cryptic order. That was an injunction.
Injunctions that was
You're not
allowed
concerned.
set aside by the order.
This has
In the course of hearing, one undertaking was given by the appellant. Page 24.
yes.
My lord, ordering portion, the misappeal be same is allowed on contest, but without cause, the order dated such and such, connection is hereby set aside. The appellant is hereby allowed to construct the incomplete building as per his existing site plan.
It says that the final adjudication, it is subject to the final adjudication of the, and the appellant shall remove it as and when any
If
direction
the
is
suit is degreed,
whatever.
should dismissed. Thereafter, my lord, appeal.
Only
My lord, I am citing another decision of the Honorable High Court. My lord. '89, volume 1, CLJ, page 447, my lord. Paragraph 19 onwards, my lord. I am reading, my lord. An entry of record of right is presumed to be correct until the contrary is shown in such and such judgment, my lord. And as such, presumption must be given effect to unless the correctness of the entry is disapproved by evidence. It is clear duty on the part of the court to give effect to such presumption unless such presumption is rebutted by evidence. My lord, here is no rebuttal.
What rebuttal? They claim their title on the strength of those the deeds.
Deed, my lord, but a plot. I am clearing to you, lordship.
Sir,
am I not clear, my lord?
I think you are not clear.
My lord, kindly.
Sir, your admitted position is that the Indro and the not Jharu, Jagannath, they were the admitted owners. You are not denying that
But
they were not there. Now, your claim is that these two persons, that Jagannath, after his death, the Jhoru and Indro, they executed a deed of sale in your favor in 1915. Correct? They say that there is nothing, no sale. Now,
how the record of right was prepared?
That is what I'm saying. That's
How
why
the record of right was prepared, my lord. I am asking this question, and
so I am putting this question to
my
you.
lord.
First sentence of paragraph 20 of this judgment.
Paragraph 20. This
judgment,
my lord.
First sentence.
I am coming, my lord. No doubt.
Yes.
An entry of record of right does not create any title in favor of any person, as raising a presumption is not creating a title, nor does it extinguish a right either.
Now, question is, this is what the court has also held.
My lord.
So when you claim title.
Next paragraph is very important. The entry create not
takes away any right.
As it is made on the basis of the possession
only. That's why
thereafter, my lord, it is not completed. But at the same time, it may be said that it is a proof of title so far as the title is based on possession.
Correct.
Thereafter, my lord, the party challenging an entry must adduce evidence to rebut the presumption of his correctness.
True. That is what who says that he cannot.
Thereafter, my lord,
No doubt the presumption arising out of a right entry in the record of right loses its importance.
My lord,
Loses its importance when the
Here-
evidence on the point in controversy is gone into in extenso
my lord,
on both sides, and such evidence
Here, my lord.
discloses no foundation for presumption.
here, my lord, record of rights is not given a go by.
That is,
Record of rights is a strong presumption of possession, and that's great for
sir,
that
possession,
possession
sir,
follows title.
that is what I am unable to, sir, understand this.
My lord,
That the mere possession follows the title. I am unable to accept this proposition of law, sir.
no, not mere possession, my lord.
So you are saying so?
No, my lord.
possession?
We have taken care of the property. We have constructed
And
it.
what does it mean?
We are
You have
uninterruptedly
not
enjoy
been
it.
able. You have not been able to prove your right as a adverse possessor.
My lord, it is a case of adverse possession. That is why trial court did not give any title.
Then it is to be based on three legal maxims.
That
Nec
applicable
vi,
here.
nec vi, nec clam, nec precario.
Right.
Have you proved all these three maxims?
We have proved.
When you have proved that your position becomes hostile to the true
Right.
owner,
Right. Why?
when you have said that I am there on that date, uninterrupted position, hostile position,
My lord.
hostility
I
is
am
one of
coming,
the
my lord.
important factor. When you adduced an evidence that it becomes hostile against the whole world.
My lord, evidence was adduced that 1915 the school was in possession. Subsequently, correction record of
Now,
right.
second question is,
Subsequently, my lord, LR record of right.
I'm again saying, sir, subsequently, suppose a long position, does it mean that it becomes
No.
adverse position?
No. 3 or 4 conditions must be fulfilled.
First thing
Here,
is,
my lord, we
first
have
thing is hostile.
hostile. Yeah.
Where you have claimed an hostile title, have you proved anything by virtue thereof?
80 years we are in possession. One thing. Second thing, my
You
lord.
say long position does not mean adverse position. Still, you say 80
One of the
years.
condition possession uninterruptedly and with the knowing fully well by the plaintiffs.
Then where is a
It is
neck?
in public.
Where is a neck V and neck clam?
My lord. My lord.
And the last is neck precario, that they must know, and yet after knowing
Long
that you have
100
claimed a right title, they have not
And
done it.
long 60 years, they did not take any action. We are enjoying the property. We are constructing the building. We are taking care of the building. That is why one paragraph I am reading from the latest judgment of the Supreme Court. My lord, kindly I am reading once more, my lord, subject to your lordship approval.
Now I will keep mum.
My lord, paragraph 22. Paragraph 22, my lord. The law of limitation apparents to remedies because the rule is that claim in respect of rights cannot be entertained if not comments within time prescribed by the statute in respect of that right. Apart from legislative action prescribing the time.
Paragraph 22. It says in Bharat Barrel.
Right. I am reading, my lord, very important line, my lord.
Oh, you're reading the quotation.
Quotation, my lord.
Say that.
A statute prescribing limitation, however, does not confer a right to action, not speaking generally, does not confer on a person a right to relief, which has been barred by a lapse of time prescribed by the law. The necessity for enacting periods of limitation is to ensure that action or comments within a particular period. Firstly, to assure the availability of evidentiary document as well as oral to enable the defendant to contest the claim against him. Secondly, to give effect to the principle that law does not assist a person who is inactive and sleeps over his right by allowing them when challenged or disputed to remain dormant without asserting them in a court of law. Last 40, 50 years, they are sleeping. All on a sudden, they wake up from the deep slumber and file a suit. The principle which forms the basis of this rule is expressed in the maxim vigilantibus, non dominantibus jura sub beniunt. The law give help to those who are watchful and not to those who sleep. Therefore, the object of the statutes of limitation is to compel a person to exercise his right of action within a reasonable time, as also to discourage and suppress stale, fake, or fraudulent claims. While this is so, there are two aspects of the statutes of limitation that one concern the extinguishment of the right if a claim or action is not commenced with a particular time. They have extinguished their title, but they did not come within the prescribed period of limitation before the court. They are fully aware the record has been recorded in favor of the school. Bata plot has been recorded in favor of Satish, Sipoti, and Rotikanto. Thereafter, self-proceed was done in favor of the Rotikanto, the 2/3 share of the Bata plot, not original plot. Thereafter, after the complete execution registration of deed in the year 1979, they did not take any action, and Rotikanto was aware of the fact that Bata plot was the owner of the Satish and Sipoti. Thereafter, his father filed a suit in the year 1986 that was ultimately dismissed for non-prosecution. Thereafter, plaintiff filed a suit when school was constructed the building over the plot in questions in the year 2001. It is a hopefully barred by limitation. Thereafter, my lord, while this is so, there are two aspects of the statute of limitation. The one concerned the extinguishment of the right if a claim or action is not commenced with a particular time, and the other merely bear the claim without affecting the right, which either remains merely as a moral obligation or can be able up to furnish consideration for a fresh enforceable obligation. Where a statute prescribing the period limitation extinguishes the right, it affects substantive rights, while that which purely pertains to the commencement of action without touching the right is said to be procedural. High Court, Supreme Court deprecates the High Court on the grounds that Section 27 is not being considered while allowing the appeal, my lord. In this case, paragraph 30, my lord, your lordship, it that the purpose behind Section 34 was elucidated by this court. It was observed that purpose behind the inclusion of the proviso is to prevent multiplicity of proceedings. It was further expounded that the mere declaratory degree remains non-executable in most cases. The court noted that suit was never amended, even at the later stage, to seek consequential relief, and therefore it was held to be not maintainable. The position of law has been reiterated in Akamma, your lordship referred it. Thereafter, my lord, while reversing the High Court degree, observed that because 34 of the specific relief act, the plaintiff not being in possession and claiming only declaratory relief, ought to have claimed the relief of recovery of possession. It was held that the trial court rightly dismissed the suit. Our case is the same, my lord, on the basis that the plaintiff has filed a suit for a mere declaration without relief for recovery, which is clearly not maintainable. That apart is now well settled. The lapse of limitation bars only the remedy, but does not extinguish the title. Reference may be made to Section 27 of the Limitation Act. The aspect was overlooked entirely by the High Court in reversing the findings of the court below. It was not justified for it to have overlooked the aspect of limitation, particularly where deciding a dispute purely civil in nature, which your lordship earlier observed. Adverting to the facts of the present case on perusal of the plaint, it is evident the plaintiff was aware the applicable relief which follows. Plaintiff himself has stated that defendant number 1 was in possession of the subject property. I am pausing for a moment, my lord. I am placing the evidence of PW1 subsequent judgment as delivered, my lord. Had sought to transfer possession of same to defendant number 1, thereby establishing that he himself was not in possession of the subject property. We are not inclined to accept submission of the learned counsel for the respondent on this issue. We note that after the death of life estate holder in 2004, there was no attempt made by the original plaintiff to amend the plaint to seek the relief of recovery of possession. It is settled law that amendment of plain can be made at any stage of suit, even at the second appellate stage. In view of the above, second issue is answered in favor of the appellant herein against the respondent. As evidence from the discussion here, the judgment impugned before us fails scrutiny as the threshold said itself, that is on limitation as also maintainability of the suit. This being the case, the judgment of the trial court in OS number 726 of 1993 and first appellate court in such and such, in second appeal, suit number such and such, which dismissed the suit of Gopal on the ground of limitation, cannot be faulted with.
Yes.
My lord, I am citing another judgment, my lord. It is also lawyer aware, lordship aware of that. 2017 volume 3 Supreme Court cases, page 702, my lord. Paragraph 34, 35, my lord. দুটো দিয়েছি।
Yes.
34, 35, my lord, this judgment. I am reading, my lord. Already section 34, your lordship have gone through it. In the present case, the plaintiff having been found not to be in possession, having only sought for declaratory reliefs, the suit was clearly not maintainable and rightly been dismissed by the trial court. In this context, the reference is made to the judgment of the court in Ramsaran versus Ganga Devi, wherein in paragraph 1 and 4 following was stated. This is a plaintiff's appeal by special leave. Ramsaran and Raghuveer Saran, the plaintiffs are bothered. They jointly own the property with Chavili Quer, widow of Lolita Prasad. After the death of Chavili Quer on 18 to 1971, Ganga Devi, the defendant in the suit, came forward as legal representative of Chavili Quer and got the mutation effected in her name in place of deceased Chavili Quer. In 1958, the plaintiffs brought the suit for a declaration that they are the sole owner of the suit property. They did not claim possession of either the entire or even any portion of the suit properties. We are in agreement with the High Court. The suit is hid by section 42 of the Pacific Relief Act. As found by the fact-finding courts, Ganga Devi is in possession of some of the suit properties. The plaintiffs had not sought for possession of those properties. That merely claimed a declaration that they are the owner of the suit property. Here, the suit is not maintainable. Now, I am citing another decision, my lord, regarding regarding presumption of record of rights. It is a Supreme Court judgment, my lord. Paragraph 7, my lord. Paragraph 6, not 7. Skip over, my lord. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10. 10 line, my lord, skip over. The appellant laid no evidence and has not even placed on record the revenue records prior to the earlier sealing proceeding or the revenue record thereafter to support actually not classified as such in the revenue record. presumption of truth is attached to the revenue record. No doubt this is a rebuttable presumption,
Who is deciding, not the civil court.
but it is for the party who alleges the entries in the revenue records are wrong to lead evidence to rebut the presumption. The appellant have miserably failed to do. The appellant also failed to lead any evidence to show the revenue entries are wrong. I am citing another decision, my lord, regarding Order 41, Rule 31. Order 41, Rule 31. What is the duty of the first appellate court? And দিচ্ছি দাঁড়ান। Citation 2010, volume 13, SCC, page 530. How the regular first appeal is to be disposed of by the appellate court, high court, has been considered by the court in various decisions. Order 41, Code of Civil Procedures, deals with appeals from original degree. Among the various rules, the Rule 31 mandates the judgment of the appellate court shall state the point for determination, the decision thereon, the reasons for the decision, and where the degree appeal from is reversed or varied, the relief to which the appellant is entitled. The appellate court has the jurisdiction to reverse or affirm the findings of the trial court. The first appeal is a valuable right of the parties, and unless restricted by law, the whole case is therein open for hearing both on question of fact and law. The judgment of the appellate court must therefore reflect his conscious application of mind and record findings supported by reasons on all the issues arising along with the contention put forth and placed by the parties for decision of the appellate court. Sitting as a court of first appeal, it was the duty of the High Court to deal with all the issues and the evidences laid by parties before recording its findings. The first appeal is a valuable right, and parties have a right to be heard both on question of law and the facts. And the judgment in the first appeal must address itself to all the issues of law and fact and decide it by giving reason in support of the findings. In view of the above salutary principles, on going through the impugned judgment, we feel the High Court has failed to discharge the obligation placed on it as a first appellate court. In our view, the judgment and the appeal is cryptic, and none of the relevant aspects have been noticed. The appeal has been decided in an unsatisfactory manner. Our careful perusal of the judgment in the regular first appeal shows that it falls short of consideration which are expected from the court of first appeal. Accordingly, without going into the merits of the claim of both parties, we set aside the impugned judgment and decree of the High Court and remand the regular first appeal to the High Court of for its fresh disposal in accordance with law. My lord, here, my lord, first appellate court did not discharge his obligations as per Code of Civil Procedure Code. He didn't say that appellate court did not touch the issues, not consider the evidence. My lord, I am placing the evidence of PW1. So lordship directed me to place it. Right. Evidence to evidence to evidence to ঠিক আছে and very old judgment delivered by celebrated judge Justice Kiznoyer of the Honorable Supreme Court. Same view was adopted, my lord. Evidence of PW1, my lord. I don't want to multiply the judgment. Another judgment regarding Order 41 Lal 13, it is volume 2022, volume 8. Supreme Court reiterated it. The duty of the first appellate court. 22, volume 8, SCC, page 261. para 26 onward, my lord. The High Court, in a very cursory and cryptic manner, partly allowed the first appeal. It did not consider the evidence considered by the trial court. Neither did it deal with the statements or other documentary evidence on record, and only on a blunt statement of the respondent, which according to it was mentioned in the order of the land tribunal. The respondent was jointly cultivating the said land along with his father, held that it became a joint family estate, and accordingly reduced the shares of the appellant to 1/4 from the 1/2. Paragraph 27, my lord. The only discussion made by the High Court in the impugned judgment is reproduced here and under, my lord. I am not reading that, my lord. Paragraph 28. Section 96 provides for filing an appeal from original degree. Further, Order 41, Rule 31 CPC provides for the contents of the judgment of the appellate court. According to it, the judgment of the appellate court shall be in writing and would include the points for determination, the decision thereon, the reason for the decision, and where the degree is reversed or varied, the relief to which the appellant is entitled. Section 96, Rule 41, Order 41, Rule 31 are reproduced here in below, my lord. Already your lordship running to. Paragraph 30. It has been a matter of debate in a catena of decision as to what would be the scope, power, and duty of the first appellate court in deciding an appeal under Section 96, read with Order 41, Rule 31, Code of Civil Procedure. We briefly deal with the law on the point. The learned Judge V.R. Krishna Iyer, as he then was a judge of the Kerala High Court in 1969, while deciding the case between Kuriyam Chaku versus Bharki Joseph, dealing with a similar judgment of the first appellate court, which has been disposed of by a brief order, observed as follows. An appellate court is the final court of fact. Ordinarily, and therefore a litigant is entitled to a full and fair and independent considerations of the evidence and the appellate state. Anything less than this is unjust to him, and I have no doubt that in the present case the learned subordinate judge has fallen far short of what is expected of him as an appellate court. Further, following the above, there have been a series of judgments by this court. In Santosh Hazari versus Purushottam Hazari, such and such, the appellate court has jurisdiction to reverse or affirm the findings of the trial court. First appeal is a valuable right of the parties, and unless restricted by law, the whole case is therein open for hearing both on consideration of fact and law. The judgment of the appellate court must therefore reflect a conscious application of mind and record findings supported by reason all the issues arising along with the conditions put forth and pressed by the parties for decision of the appellate court. While reversing a finding of fact, the appellate court must come into the close quarters with the reasoning assigned by the trial court, and then assign its own reason for arriving at a different finding. This would satisfy the court hearing a further appeal that the first appeal court has discharged the duty expected to do it. The first appeal, paragraph 32, my lord. The first appeal has to be decided on the facts as well as the law. In the first appeal, parties have the right to be heard both on question of law as also on facts. And the first appellate court is required to address itself all issues and decide the case by giving reasons. Unfortunately, the High Court in the present case has not recorded any finding either on facts or on law. Sitting as the first appellate court, it was the duty of the High Court to deal with all the issues and the evidence led by the parties recording the finding regarding title. Paragraph 32(3), my lord. In our concerned opinion, the High Court did not deal with any of the submission urged by the appellant and the respondent. nor it took note of the grounds taken by the appellant in grounds of appeal, nor made any attempt to appreciate the evidence adduced by the parties in the light of the settled legal principles and decided case law applicable to the issue arising in the case with a view to find out as to whether judgment of the trial court can be sustained or not, and if so, how, and if not, why. Being the first appellate court, it was the duty of the High Court to have decided the first appeal, keeping in view the scope and powers conferred on it under Section 96, read with Order 41 with 31 Code of Civil Procedure mentioned above. It was unfortunately not done, thereby resulting in causing prejudice to the appellant whose valuable right to prosecute in the first appeal on facts and law was adversely affected, which in turn deprived him of a hearing in the appeal in accordance with law. It is for this reason we are unable to uphold the impugned judgment. Very recently, this court in 2022, which one of us, Badar Abdul Nazir, was a member, Mundula versus Samsundar, reiterated the same view in para 8. Section 96 Civil Procedure Code provides for filing an appeal from the degree passed by the original jurisdiction. Order 41 Rule 30 provides the guidelines of the appeal court with which the appeal. That was there. Thus, the appellate court has the jurisdiction to reverse or affirm the findings of the trial court. It is settled law that an appeal is a continuation of the original proceedings. The appellate court jurisdiction involves a rehearing of appeal on question of law as well as fact. The first appeal is a valuable right. At that stage, all question of fact and law decided by the trial court are open for reconsideration. The judgment of the appellate court must therefore reflect conscious application of mind and must record the court's findings supported by reasons for his decision in respect of all the issues. Findings supported by the reason for his decision in respect of all the issues along with contentions put forth and praised by the parties. Needless to say, the first appellate court is required to comply with the requirements of Order 41 Rule 31 Code of Civil Procedure, and non-observation of these requirements lead to infirmity in the judgment. The Honorable Supreme Court set aside the judgment, my lord.
Yes.
My lord, I am placing the evidence of PW1.
Still.
Evidence of PW1, your lordship. I am praying, my lord. It is a type copy, my lord. Photostat copy of the certificate copy marked with ink, my lord. That is why I am. This.
Yes.
I am reading the evidence deposition of PW1, my lord. Shantimoyi Manna. I have filed my examination in chief from an affidavit. The said examination will be drafted as per my instruction. I put my signature in the said after going through its content. I have filed the certified copy of the sale deed executed by Sri Satish Chandra Manna in favor of my father on 23rd February 1964. The said certified copy of the sale deed is marked Exhibit 1. I have also the certified copy of the sale deed executed Satish Chandra Manna in favor of my father on 21st September 1966, marked as Exhibit 2. I have also filed a certified copy of the sale deed Satish Chandra Manna in favor of my father's 7 September 1969. The said certified copy of the said deed is marked at Exhibit 3. I have also filed a certified copy of the said deed executed by Sipoti Charan Manna in favor of my father on 24th April 1969. The said certified copy marked at Exhibit 4 and 5 respectively of the said sale deeds are. I have filed a certified copy of the district settlement ROR record of rights. Those copies are marked at Exhibit 6. I have also filed a certified copy of the RSROR. Those certified copy marked at Exhibit 7 series. I have also the filed certified copy of the LRROR. The same is marked at Exhibit 8. I have also filed the revenue receipts of the said plot. Those are marked at Exhibit and a cross. Father of Jagannath Manna is Bhajahari Manna. I have no paper in respect of the same. I have also no paper to show that Jagannath Manna and Indra Manna are two brothers. I have also no paper to show that Jhoru Manna inherited the share of Indra Manna. I have stated the said fact on the basis of my assumption. I have no paper to show that the entire share of Indra Manna was inherited by Jhoru Manna. The entire share of Jhoru Manna was recorded in the RSROR in the name of his three sons, Sipoti, Satish, and Otikanto. In the DSROR, plot number 3051 was recorded in the name of Jhoru Manna. DS record in respect of plot number 3051 was shown on the witness by the learned advocate for the defendant. Thereafter, witness says that the entry in the DSROR in respect of the plot number 3051 was wrongly made. I have no paper to show that plot number 1351 belongs to Indra Manna and Jhoru Manna. It is stated that entry in the DSROR in respect of the 1351 was wrong, as the said plot as in our possession since the time of my father. In the RSROR, plot number 3051 was recorded in the name of a school, and the said entry is also erroneous. There is a Batadag of plot number 1351 in the record of deed rights. The said Batadag was recorded in the name of the school erroneously. Not a fact that plot number 3051 belonged to us. Not a fact that plot number 3051 was correctly recorded in the name of the schools. Next page, my lord. Sipoti Manna transferred his share in all the suit plots to my father. In the deed executed by Sipoti Charan Manna in favor of my father, the Batadag were mentioned. In the deed executed by Satish Manna in favor of my father, only Batadags were mentioned. In other three deeds, no suit plot were transferred. I do not know whether my father had filed a suit against the defendant school prior to this suit or not. I read out the written statement filed by the defendant. It was written there that my father had filed a suit on the basis of those deeds before this court, but I did not make any inquiry in respect of the same. I do not know whether my father had filed title suit number 17 of the year 1986 or not. In the suit plot, there is no school. The suit plots are lying vacant. The local inspection was held in respect of the suit plots, and the learned commissioner submitted his report before this court. In the said report, learned commissioner shown the suit plot as vacant land. Some portion of the suit plot, there is the school building. The rest portion of the suit plot is used by children as playground. Not a fact, the original plot was recorded in the name of the school as Indra Manna given his share to the school. share the Jhoru Manna was recorded in the name of the legal heirs at Batadak. Not a fact that we did not possess the suit plot number 1351, as is Batadak. We did not make the legal heirs of Sipoti and Satish Manna as party defendant in the suit. Not a fact that on that ground, trial court holding inter alia, the suit is a defect of parties. Plaintiff are claiming the share of Satish and Sipoti, but heirs of the Sipoti was not made party in the suit. Not a fact that my uncles know the entry in the RSROR, and as such they transferred only Batadaks in favor of my father. Not a fact that we have filed this suit falsely in order to grab the property of the school. That is the division, my lord. It is admitted fact. The Satish and Sipoti transferred the Batadak. School was in possessions, and heirs of the Sipoti were not parties in the suit, although they are claiming the property of Satish and Sipoti. That is my lord submission subject to law. I am grateful to you.
Yes. Keep it on Monday. I will dictate in the open court. और कच्ची पटरी दो. I will dictate in the open court.
না দেখবেন তো দিয়েছি
এইভাবে আমাকে পাঠাও.
A translated copy of the entire record of rights I have given, my lord, pursuant to your lordship orders.
That I'll take care of. Don't worry. Call the next matter.
Well, I'm for the appellant. And pursuant to lordship orders, I have served copy upon the one respondent. Lordship DR was that to have copy upon the respondent.
Are they appearing?
No, they are not appearing, my lord. On the last occasions, my lord, when the application for registration, he also served, they did not appear. Thereafter, my lord, this matter was taken up by your lordships, and your lordship, this is a short matter. Your lordship's DR was that to against the order of remand.
What can be done? If they do not appear, then we'll have to either admit it and then keep it pending. We can't go beyond that.
Hello, on that day, your lordships, well, this is
Yes, we wanted that if they come, that we can dispose of at the order 41 level at that stage.
Yeah.
But if they are not coming, then can we dispose of in their absence? We can't. Then we'll have to otherwise admit, and this is a remand.
yes,
This is what is there. No, it's not a remand.
yes, this is the order of remand.
It says that title appeal B and same is allowed and contest against the contesting respondent, but without cost. Where is the order of remand?
Your lordship, kindly.
Oh, however, this court is of the view there is a fit case to send to open remand.
Yes.
Then what to be done? It has to be admitted.
Then you also admit.
Yes. The appeal is admitted.
This is my lordship.
Is there.
Yes, trial court lawyer.
Can you serve the trial court lawyer?
Then I shall serve again, my lord.
Then we are not, because if we can dispose of the matter.
let me take a chance, my lord. I shall.
Yes, the affidavit. Next week we are taking up the applications.
1 week more because service, my lord, it is affected.
By hand, sir. You
Yes.
send it by hand.
Yes, sir.
Do it by hand. Let's call the next.
Item 29 are led by Mr. Atish Kumar Vishwas. Due to some personal difficulty, he is unable to come. Praying for 1 day accommodation.
You are a advocate on
Please,
record.
No, my lord, I'm not an advocate.
Where is Mr. Amit Singh?
Lord, I'm not instructed.
He is the advocate on record.
He's too unable to come, my lord. In this matter, Mr. Atish Kumar Vishwas is appearing.
The junior, the advocate on record must be here.
He's not in court right now.
And this is the 2020. Then let it go out of list. Let it go out of list.
Only 1 day accommodation. Thank you.
Not today. Yes.
My lord, I'm on behalf of the respondent. The petitioner is not present.
What to do, madam?
My lord, this is the second time they filed this appeal. On the last occasion, they had said they'll be providing us with a fresh copy of the plaint because the cost title they was wrong. The number was missing, but they have now taken none steps.
Who is the advocate? Mr. Oyen Mondal.
My lord.
Are you known to him? Do you
No, my
know
lord.
him?
No, my lord.
No. Yes, not today in their absence. Now we can't dismiss it. Yes.
And my lord keeps it on the next day. Great.
But the other side, who has appeared?
My lord, in this matter, Mr. Devendranath is appearing for the petitioner.
But
Which
I am
side,
appearing
the
online,
street
my
and all?
lord.
That side, my lord.
Can you inform Mr. Mukherjee, Tapan
Yes, sir.
Mukherjee, and inform Mr. Majumdar also,
Yes, ma'am.
who was appearing for
I
IIT?
am appearing online.
Yes,
I am appearing online on behalf of the petitioner, my lord.
petitioner, somebody is here. I
Yes, my lord,
want
he
the
is
other
my-
side to be here.
my lord.
I shall inform.
Inform,
Yes,
inform.
thank you. Wait.
Call the matter. Call. Enter her regular list.
But I am the applicant in this one. But there are some defects, Lord, which are, Lord, your lordship are directed to remove. But Lord, one of the defect is, Lord, that has to be sent down and Lord, the removed by the learned judge in the
That will
court,
take
Lord.
care of that.
And Lord, there was a, Lord, a deficit court fee, Lord, directed to be paid. That has been paid on, Lord, 14th of March.
Out
Lord,
of time.
out
Out of
time.
time. Extended the time for the which is not within the. Stop. Seen the note of the assistant registrar and the superintendent put on the file. Uh, the uh, the deficit court fees filed by the appellant
Dismissed on the ground, Lord, that, Lord, I'm a Thika tenant in. The ground was not that expiry of lease, and my
By a
defense
flux of
was
time.
by a flux of time. It was a
Yes.
30 years lease.
Suit was dismissed by the trial court.
Yes, on the ground that I am a Thika tenant, and therefore, Lord,
And the appellate court has
jurisdiction.
reversed.
on Lord, applying money squares review judgment. Now, Lord, I am to show before your lordship, Lord, that how I am falling within an exception.
You just first show me that the deed of lease.
My lord.
It's such a voluminous judgment. Show me the deed of lease.
My lord. Yes. এটা আমাদের এই অ্যাপ্লিকেশনের মধ্যে আছে তো তাহলে বাঞ্চের মধ্যে আছে for the terms of the lease deed. And these two flagged pages are the.
This is not included here.
So these are part of the exhibits.
Not included here.
No. The dog-eared pages are not the lease, and the flagged pages are not the two documents that I'll rely upon. For Justice Prasad also. The dog-eared pages, my lord. Those are the blood. The Tika controllers, my lord, reply, and my lord, the Form A that I had filed, and my lord, the terms of the lease deed, and the corporation, my lord, the record which shows that it is a Tika property. Exhibit. Thank you. Trial executed to Barcelona. Last bill. $17. That's one thing.
Between the Knitters and the Sharma. So,
My lord, your lordship will kindly come to the flagged pages. Your lordship will find, my lord, that we have adduced evidence to show that, my lord, this property was already recorded as a Tika property. My lord, the letter given by the Tika controller says that it is already recorded. The corporation tax bills, my lord, says that, my lord, the government of West Bengal is the owner of it. I have filed, my lord, Form A within time as stipulated, and that was accepted, and, my lord, the rent was being paid. This aspect of the matter, the learned, not the appeal court, who reversed, my lord, did not come to any independent finding, only, my lord, two findings taking clue from, my lord, the money square judgment. He has quoted almost the entirety of the money square judgment.
Where is the money square?
That your lordship will kindly come to, my lord, internal page 25 is a decision with reasons by the appeal court. Internal page 25 of the appeal court. Then, my lord, the very next page, my lord, he starts quoting from 1004, 10.4.
25.
Page 25 is the decision with reasons.
Yes.
Then, my lord, from next page, page 26, 10.4 is, my lord, the quotation coming from, my lord, the money square judgment in review. Then, my lord, the entire judgment, almost entirety of the judgment has been quoted. It goes up to page 79. And, my lord, the reasoning by the judge is, my lord, your lordship will find at page 81, two paragraphs. In view of the above, the erection of pakka structure and lease period being 30 years do not, I'm sorry. (10.27) is, my lord, the finding of the appeal court in reversal. But it starts from page 26 at that we have missed because
what do you have missed?
Because it has been quoted almost, not in the. Your lordship will see, Lord, the from page 26 onwards, Lord, it is a quotation, Lord, bodily lifted from the judgment. Page 26 to 80. আমার কাছে আছে আইপ্যাডে আছে তোর কাছে আইপ্যাড এনেছিস
What you are saying, let us think about it, because those are the, as if she has said that what is her own view.
But I have 2 points.
If you say that this is really a reproduction or a repletion of the
I
judgment,
can show from the iPad, Lord. I have it in the iPad.
then in that event, the case of a
up to 80 Lord, there is a quotation.
It's a case of a plagiarism.
But the learned judge, Lord, has
the plagiarism
volume by Lord typing out and Lord then coming to them, Lord, the decision at page 81 on 2 points without considering, Lord, the material evidence.
But she has quoted or
quoted up to 80, page 80.
She has not quoted.
But this
It
is
does not appear that she has quoted.
No, she has not typed it out as if not it is an order of the court.
Yes, that is what I am saying. That is what
not
I
even
gather.
yes, Lord, yes. These are bodily lifted from the paragraphs and put in by Lord this paragraph marking in the judgment. And the findings at page 81 only, 10.27.
Plagiarism.
The bare fact that this was already not recorded as a Tika property.
I have no occasion to read that judgment of the review. I do not know. Is it a reported judgment? A review?
Yes. My Lord, I have a copy. My Lord, I'm just giving your lordship, Lord, but I shut up.
No, but
later on she's continuing as if she's dealing with those points and all everything. I think she being put in judgment, sir.
Lord, the money squares judgment. Lord, kindly excuse me, I have only.
No, so far as this, he is talking about this one from 10.5 onwards. I also do not think so. Review judgment.
Review judgment. Then in view of the above, 10.27 is the finding.
It appears she has quoted from 10.14 onwards.
10.14 onwards.
But it is within quotes.
But I have seen, Lord, that is not the judgment of the.
No, but it is within quotes. See page 37. Or it starts from 36. Held as follows, then it opens the quotes and then it is within quote. It is not as if she is writing the judgment. Every paragraph is within quotation. So it starts with an opening quotation and ends with the closing quotation. Every paragraph.
And thereafter, Lord, the reasoning is the last.
Maybe borrowed certain expressions from the judgment, but in her own language. She
Then, Lord, the question of law that Lord falls, Lord, that Lord, the learned judge should have considered, Lord, the effect of a property which is already enrolled as a Tika property without a challenge thrown by the landlord before the Land Reforms Tenancy Tribunal. The Manish Kumar case, not the operation of the amendment was stayed. And not if your lordship sees not page 3 of the trial court, not the evidences that I have adduced, I have flagged not the evidences, some of the evidences. Primary evidence was not the TICA controller says that the property is already a TICA. One. I have adduced not the documents.
There are
to say,
two aspects of the matter.
My lord.
There are a line of judgments delivered by our High Court.
My lord.
That the effect of 1981 Act or a 2001 Act will only take effect provided there is a subsisting TICA tenancy as on the date of coming in force of the acts. If the TICA tenancy comes to an end prior to coming in force of the act, then in that event, whether a person can take advantage under the aforesaid act. That was also held by our High Court that no, there should be a subsisting TICA tenancy on the date that is which 1982, that when 1981 Act came into force.
With effect from 82, August 82.
Here is a lease, I believe, that ended prior thereto.
It ended in 1987. It was a 30 years lease, registered lease.
57? Yes.
57 to
Yes,
August
30.
1987. And I filed not after coming into force of the 81 Act, my obligation was to file not the Form A.
Don't allow Mr. Mukherjee to go out. Mr. Tapan Kumar Mukherjee.
And Lord, pursuant to Lord, the determination by the TICA controller, Lord, this property has been mutated in the name of the government as a TICA property. And the suit was filed in Lord 1993.
Cited.
The conclusion, page 1, paragraph 126. The conclusion paragraph, Lord, yes. But I'll get to that.
Give a thumb impression or a face recognition.
Online. 2022 SCC online, SC 920. Para 126 summarized.
Withdrawn. Structure is the situation, what to be gathered. So far as the Lokhiwani Dasi's case was concerned, the state government withdrew that appeal, and it is affirmed in this order.
High Court order is affirmed. SLP was withdrawn.
It's in Lokhiwani Dasi, Justice G.N. Ray, if I correctly remember, the special bench held certain provisions of the 1981 Act to be ultra vires. Then a leave to appeal before the Supreme Court was sought here in the court. That was granted by the special bench in view of the very special character of the question, the involvement of the point of law. So that straight away the appeal was filed before the Supreme Court. Then later on, after 2001 Act
It was withdrawn.
The appeal was withdrawn. Then after the withdrawal of the appeal, judgment is affirmed. So, meaning thereby, the virus remained. Ultravirus.
It is.
Cleared ultravirus.
True.
So how can you get it a special status under this act, which is ultravirus? Tell me.
But all provisions were not, that was not because there was no
Now the
provision
question
for
would be, I
not
tell
giving
you,
the compensation.
I do not know.
That was the vice blood which was corrected in the letter, not the enactment.
What? Where is the letter, Judge?
No,
After
the
this?
letter enactment, I mean to say.
More dangerous. Deemed to have been wasted on the promulgation of 1981 Act. So, 1981 Act is declared ultravirus.
But compensation has been newly introduced in the.
But this was affirmed. But 2001 Act has not been challenged anywhere till now. To my knowledge, no.
No. No, নতুন টিকা নেই। নতুন যে টিকা গুলো হচ্ছে ফোরাম চেঞ্জ হচ্ছে অনেকগুলো তো থাকতে পারে।
Is the Pakka structure. The second part. And secondly, you have raised a Pakka structure.
But that is not one thing. Not the
One
only
thing means that's the major thing.
No, Lord, it is a tin shaded structure according to Lord the
Did you
corporation.
obtain the permission of the government
Yes.
or the landlord to raise a Pakka
But
structure?
the landlord's permission is ingrained in the lease.
What?
Lord, I have already flagged that. That is there. Even Lord, the permission to sublet was there in the original registered lease.
Where is the evidence that it was a tin shed?
Lord, if your lordship kindly sees the first flag. Lord, in the form A, it is not the last column is tin
It
shed.
was a
Form A.
Kaksha.
Form A file.
Form A.
Lord, and Lord, the corporation, Lord, the record speaks
What
of the
records? What it says? Form A?
But at the bottom, Lord.
At the bottom what?
A tin shed.
No, shed may be a tin, but the structure is of built, not of mud.
True, Lord.
So-
That is, I don't say so, Lord, that it is not. But that is not the only one criterion, Lord, is to be seen.
You know the judgment, there are judgment of Justice P.N. Mukherjee's also. If it is surrounded by a boundary wall, that's a structure.
Lord,
It was
your
considered
lordship
to be a
looks at
structure.
that point of view, Lord. Lord, it can come within the definition of a Pakka structure. But not so far as Lord, it is already enrolled as a Thika tenant.
10.3, it says is a Pakka structure more than 20 years. Now, you are more than 30 years.
But I'm not saying so, Lord, that
Then
I am
below
calling
12 years, below 12 years. It has to be below 12 years.
It was erected in 57 itself.
My-
This structure was erected in 57 itself.
Yes. That was when Lord 49 Act was in force. But Lord, the money square judgment also
49 Act
takes
says-
care of Lord the
Sir,
49 Act.
49 Act says that lease must be below 12 years. So any lease which is there above 12 years will not come under the purview of the Thika tenancy. 1981 Act defines the Thika tenant in a very, very broad manner. It does not make any distinction. But still, if this judgment is there, it says that on the date of coming in force, there should be the Thika tenancy. The Thika tenancy in view of the provisions contained in section 2(5) of the 1949 Act. Here, your lease expires in 1986.
87.
Whatever. 2001 Act came later.
Yes.
As on 2001, you were not. This is
the
what the
suit-
spirit of the judgment is.
And the suit was filed in 1993. When 1993 the suit was filed, I was already declared as a Thika tenant. So the question was,
the
Lord,
new
whether
law has come, if the new law has come, then what?
Lord, that was Lord,
Does not create
during the
any right.
pendency of Lord the suit. And for that reason, the trial court said, Lord, that the suit was not maintainable. This is not a case where, Lord, I am not a declared Thika tenant by the authority.
On the day when the lease expired, in 1993, there were
Two of Lord, the criteria are taken, the length of Lord, the lease and Lord, the pakka structure. Lord,
you're
then,
out.
then
Sir,
Lord,
the spirit of that those sub clauses are there are two things. First thing was, as I said, Justice N.K. Mitro's judgment, Justice Altamas Kabir's judgment, as their lordships they then were of this court, was that on the day of coming in force of 1981 Act, there must be a subsisting Thika tenancy. If the Thika tenancy goes prior thereto, then this act cannot be extended to them. I think probably that was taken into account in this judgment also. Reason being, I am telling you, reason being 10.3, this 0.3, what is this, 100 and?
126.
126.3. That was the reason. Then, once the 1981 Act is declared as ultravirus, and the first condition is that I affirm the judgment of Lokimani Dasi. That means the 1981 Act is not in existence, being declared as an ultravirus. So the position is that there is a 2001 Act, 1981 Act has been erased from the statute or whatever the statutory, the repository of whatever. It is no longer there. So the court has said that when 2001 Act came into force, it appears that the lease was for 20 years. In that case, and the lease expires in 1993 after 1981 Act came into force. Kind of explain. Therefore, this lease is not in conformity with Section 2(5) of the 1949 Act, means below 12 years. So, as on the date of 2001 Act, there was no subsisting Thika tenancy.
But additionally, Lord, the Supreme Court judgment takes care of another. Very well.
Later on. But this is what I am on.
So the reasoning was because of the interim order passed by this Honorable Court staying operation of the 1981 Act.
No, that is what it says.
Wherein, Lord, the definition was changed.
That the Act of 1981, it says, conclusion, that is a 4. It says that the appellant were not a Thika tenant within the meaning of 1981 Act for two major reasons. Why he was not? First thing is that the structure in question was a pakka structure, which is also here. That the Act of 1981 was not operative in relation to a property in question because of the stay order passed by the court.
Yes.
Two things. Then, on the date when the lease expired in the month of November 1993, please, 1981 Act, I think 1980. Lakshmani Dasi's case was filed. 1983, the Lakshmani Dasi's case was filed. And it was decided later on. 1993, the appellants and their predecessors were not a Thika tenants. And therefore, the Act of 2001 does not inure to their benefit. So, 1993 expiration does not create any right in them. Two reasons. Reasons being that it was within the meaning of 1981 Act because they were not a Thika tenants, having held more than 20 years and having held that it is a pakka structure.
But
Not making anything on that, I know, but I'm keeping.
And Lokimoni Dashi was decided either in 1986 or 87.
It's a larger issue.
But
Let us go into this. Where is
Very
the
well.
parent judgment?
My lord, this is a review of which judgment?
Review of the parent judgment.
Justice Jyotirmoy Bhattacharya's judgment is there. Review of the parent judgment, my lord, that is there. Yes. Yes. Yes, my lord.
Where it is?
But that is also reported, my lord. I can find it out for you.
Shared judgment. I think, if I am not wrong, by Justice S.J. Mukhopadhyay. Can you give the citation?
Yes, I can give. Yes.
What is?
I'm sorry. Yes, actually. 2015, volume 14, SCC 203.
Give it to us.
The barcode of this. Accept.
I have a knowledge till that judgment because before Justice Bhattacharya,
This one. The parent judgment. Oh, after before any. Okay, I take to the, excuse me. আরেকটা আছে আরেকটা As your lordship pleases me.
judgment delivered at General Magistrate.
The lordship, he is engaged in court number 13 matter. We are contact Mr.
Majumdar.
My lord,
No, we have published it in the supplementary list. That's why we wanted to, anyhow, we deliver a judgment. It's called the supplementary.
we have directed for accepting the resignation and release of the service within 24 hours.
Grateful, my lord.
My lord, I am happy above the respondents. My lord has passed the judgment in 2019, 24 April. On that judgment, my lord, page number 7, it is written as page number 7. It is written as
Table 9 from the bottom.
2003, but actual the gift it was in 2013.
5th July 2003. It should be 5th July 2013.
13. And my lord, page
Where
number.
will get it?
My lord, the deed.
From where will get it?
My lord, already I have annexed the deed. Already I have annexed the deed.
Where is that?
My lord, the petition. What is the petition?
Oh, just a second.
No. There's no paper book. There's no paper book, just scan application. Can 10.
Can 10?
Yes, my lord.
Can 10.
Can 10, 2023. If you want, এটাকে যথাশক্তি দিয়ে দিতে পারেন আমার কাছে
Give it to us. উনি দিচ্ছেন দাও।
The deed is already
What
annexed.
are you referring?
Sorry? My lord, this is the order and
The
the
judgment.
judgment is, and very to next page, I have annexed the deed.
Page 23
Page
bottom.
20 page.
23 bottom, my lord. Page 23 bottom portion, my lord.
আচ্ছা, ঠিক আছে। এই
Okay. And my lord, page number 8.
July 2003 আছে।
I am
It is,
opposing.
it is written as dependent number 2 that have
Page
Salah
number
1/3 share. Page number 8 of the judgment.
Yes.
It will be dependent number 6 because my lord.
No, my lord, I am opposing, my lord.
My lord, kindly come to
I'm
page number 7 again. Judgment. It is clearly written that in favor of Mr. Chatterjee, just last para, it is added respondent number 6.
My lord, kindly read full thereafter, my lord. The preliminary decree was passed in June 26, 2013. Since the said transfer was made after passing of the preliminary decree, the instant appeal is against the said preliminary decree. The transfer made by the respondent number 2 in favor of the respondent number 6 has no impact while adjudicable of instant appeal. As such, the said deed is not taken into consideration.
Then cannot go.
Yes, my lord.
No, sir. Sorry, refuse.
Yes.
Only 2013.
5th July 2003.
Kindly state that matter has been refused because PR is there.
No.
Plus PR is there. PR portion, he mentioned that.
Oh, he has filed an application for
Yes,
that?
yes.
Oh, then
The correction application is there.
No. Application to the
I will page 11.
PR portion page.
আমাদের application কোথায় আছে? Can 10. Can application তো বার করতে হবে। এভাবে হয় না।
Already I have filed in the regular process.
Mentioning which court?
This court.
It is appearing in the list.
Number 2.
Appearing also to list.
Appearing in the list also.
No.
দেখো তোমার এই কোর্টে ফাইল করেছে তো কোথায় যাবে? Number 4. CN 10 is only correction to that effect, nothing more. দিয়ে দেবো, বার করো।
I'm the. সেটা বললেও তো বের করতে পারবে না প্রত্যেক কিছু ফাইলে 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 চারটে করে ওখানে দেখেছো ফাইলিং ডেটটাকে দেখো খাতাতে দেওয়া ছিল
Extra.
My lord, already the copy I have given.
Oh, do you have the extra photocopy?
Extra
You can
photocopy.
take it on record.
My lord, my lord.
If it is not here.
My lord.
ওইটা 10 note.
Oh, this is not.
ওইটা
Yes, sir. Yes.
HO.
Yes, my lord.
যখন ম্যাটারটা লিস্ট হয় তখন একটু বার করা যায় না বাবু রেকর্ডটা
is the peer.
This is an application.
But one new thing I've noticed today, when your lordships were dictating the order in the screen, it is showing that order dictation in progress.
Has to be.
Yeah.
Under the model rules relating to live streaming, there are certain things which are required to be incorporated. And it is highlighted that when there is a dictation is there, then it should show that the dictation is in progress.
Also.
So dictation of the order may not be there.
Not to be heard by the public at large.
Should not. And there are certain classes of cases which should not be live streamed.
Definitely.
Relating to any offense against a child, relating to a matrimonial cases, all these things should not.
Well, this is an application for review of a judgment delivered by this honorable bench. Well, I don't want to take refuge to the leave granted by
What I
the
have committed wrong.
But it's not a wrong, Milord. It is an error by which, Milord, certain documents which were not on record somehow crept into your Lordship's order, for which, Milord, we are before your Lordship's, Milord. I'll tell your Lordship what the brief facts is. Milord, I was awarded, Milord, with a contract by the ECL, Milord, for hiring of heavy earth moving vehicles, Milord, for the purpose of transportation. Now, Milord, for this, Milord, there are diesel is required to be purchased by me.
948 days according
Oh, then that has to be
48 days.
that has to be
them.
considered first.
Yes.
What is the ground for delay?
But could I say this, Milord? Your Lordships have held, Milord, review under 226 is in exercise of power under Article 226 itself.
That is that judgment, though it is inheres and inbuilt into
Yes.
the High Court. There is no difficulty right from 19, I think 54 or 5.
In fact, it is extended to Article 215 also.
It's a code of record.
Yes.
That was the contention that it is inbuilt and inhered into the High Court.
Yes, filed.
But
Yes, filed in
but
48 days.
the moment the review is there, can it be done? Can any issue be kept open for eternally?
Milord, my explanation primarily is, Milord, I went before the Supreme Court. The matter was there before the Supreme Court for a certain period. Thereafter, Milord, the Supreme Court had dismissed our SLP with leave to file review. But I don't want to take recourse to Supreme Court order on that point. I want to take recourse to Supreme Court order for, Milord, explaining the delay. Now, the problem is, the defense says যে তুমি তো file করেছো. Now,
948 days.
where the problem is, Milord, the judge.
Mr. Mukherjee, we have delivered a judgment. You were not here. 24 hours is given to give them an objection certificate.
That retirement. Resignation.
No, resignation.
Resignation.
I have to give. No, immediately it will be. Don't worry about it. But don't wait for this uploading of the copy. Just we are communicating you. Your knowledge is imputed right now.
And content will also lie against you.
No, I do not. I never say. It is all the imputation of the knowledge because he came, he left, he was not there. So we wanted that he should know. That's only for your information. Otherwise, whatever you want to do, do it. There is no difficulty. Yes.
কি চাইছো কি? বলছেন তো? কি করবে বলো না?
No, review. I have some reservations.
Reservation made on the issue of limitation. But we have.
Let me see. Let us consider it.
Yes.
When you talked about the review of before the High Court being a constitutional court and the constitution provision And there is a judgment of the Supreme Court also, I think. This says that it is inbuilt and in here. Then one analogy I just really want to draw on the basis of this Pallav Seth's matter. When a contempt matter was taken up and it went up to the Supreme Court, then the question arose was, our High Court decision was, division bench, that so far as the contempt is concerned, no question of limitation. Anytime anybody who comes and makes a complaint that your order has been violated, the court will take into account. Then the question arose that if there is a period of limitation provided in the statute, like section 20, if I am not wrong, whether the contempt application should be heard by the court beyond that period of time. In Pallav Seth matter, if my memory goes right, it says yes. It's a limitation. Contempt of Courts Act, maybe Article 215, but that is not an unbridled power. That Constitution says that the High Court can punish for his own contempt that emanates therefrom. No, it has to be in accordance with the provisions of the court contempt of 1 year period is provided there. If the same analogy is taken, when there is a statute in place, a review is filed, taking aid of that, and there is a period of limitation provided in the Act itself, why not the court take into account that? Why not? Is it not giving a more premium to a particular category of the cases?
But first is, my lord, nomenclature.
That's why I say category. When I talk about category, is a nomenclature. I mean that.
Right. Now, my lord, our High Court has held, division bench of our High Court has held, in the exercise of writ jurisdiction, what application comes before the writ court is immaterial. Suppose I file a modification application and your lordships feel that no, over here, a modification application will not lie.
That would really, I appreciate it. That would tantamount that even if the party to a writ petition, if he feels after a gap of 10, 15 years, that no, this order I want to review, then in that event, every time the High Court has to consider the application for it. It is not that it's a PSU or it's a government or a semi-government of an authority under Article 12 of the Constitution. There are certain private litigants also implicated as a party, but the nature of or the nomenclature of the proceeding is the determinant factor, as you want to say. So they can also come after 15, 20 years.
But there's another aspect of the
Now, second, even if the limitation does not apply, then it's the High Court is not denuded of power in rejecting on the ground of delay and lapses. As in the writ petition, there is no period of limitation, but the High Court refuses to exercise the discretion.
If the period of limitation ordinarily for the suit has expired. But there's another aspect of the matter.
Mr. Bardhan is very keenly assessing the observations of the bench.
Yes.
He's evaluating and assessing all the time. As we perceive from facial recognitions.
Now, my lord, the other aspect of the matter
Record hearing.
সোহম দে ধারা, তাই তো?
Was the advocate record in the record? Why we have to change the advocate?
এইটা জানি না আমি তো। তুমি জানো?
No, names are appearing from the judgment. That's why you must.
কি ছিল বলতো? আমরা কি করলাম?
05. These are permanently here.
I was aware this was coming.
But he did not make me aware.
This preserve for all time. Give it. Tag is also given. Like
The same lawyer who must file the brief.
Yes.
Read that. 1005, if I correctly remember.
Yes.
And the consequences. Ultimate consequence.
First paragraph. Start.
But I've seen it, Miller. But the problem over here is, as I could gather, I cannot take consent of that person. But this, my lord, this order of the yes, that I can't. Yes. No, Mr. Mitrov was senior Mr. Mitrov. No. Consent of the advocate on record at the earliest.
Because Mr. Mitra is not coming.
Hmm.
He's not coming to. And I'm sitting in his chair. I'm sitting in his chair.
কাকে মনে হচ্ছে কালিমুদ্দি মন্ডল নাকি me very selected cases. Well, I don't find time. Well, I have to serve the state first. First priority is the state. Well, whichever brief I accept, I say that very well. But in fact, in paragraph 5 of my condonation application, we have said this about Millard, the difficulty with the previous advocate on record.
1005.
Section 5.
Short directions for applicability. Gives short directions for 940 days according to. Leave it to you.
But if your lordship may kindly fix a date, because 2 benches are to be. Yeah. Yes, that's what I'm saying, Miller. So since if I may, Miller, request, both your lordships are in difficulty, Miller.
In the meantime, my lord, quote 7, my lord, 6, quote 7.
Where my lord, I take courtroom number
Second half,
My lord, but only, my lord, if I may, my lord, transgress my limits. But there's a general direction in the single bench list of Justice Bhattacharya that every Thursday, second half, his lordship would be sitting singly. This is the general direction. So we expect that on Thursdays. Yeah. Wait. Wait.
Great.
সবকটা একই তো নাকি?
Two, three analogous. 2, 3 and 4 analogous.
2, 3 and 4 analogous. No, analogous. Same. I'm great from that.
First, yes, my first time, no, I can say that first time. 1/4/2019, Lordship passed an order directed to serve notice. In the meantime, during my Corona, they one of the appellant died, and this yes, there's 1/4/2019 Lordship passed an order directing to serve contempt notice upon the contemptor. No matter this, what happened, Lordship kindly see that contempt application is pending. In the meantime, appellant number 1 died. Now in the appeal we have already substituted, and now here my contempt application, and number 3 of 2022-20. In the meantime, one of the appellant died, appellant number 1, petitioner, and that petitioner has been substituted in the appeal also, in the main appeal. Now, here the contempt application needs to be substituted. ES1 application can number 3 of 2020. August 2020 and we filed in November 2020. uh, 2019. Definitely, lawsuit can regular bench this matter.